Hi, and welcome to our virtual Justice on the Block informational clinic, which will be discussing self-help evictions and what to do if your landlord is engaging in prohibited practices or retaliatory conduct. My name is Charlotte Waters, Communications Manager for Legal Services of North Florida, and with me today is Alex Richmond, Staff Attorney for Legal Services as well. Welcome, Alex.
Hey, good morning.
Good morning. So let's start with what are self-help evictions, Alex?
Yeah, so this is especially important information right now. With so many people protected by eviction moratoriums, it's entirely possible a landlord will try to do a self-help eviction. So under Florida's Landlord-Tenant Act, it lists certain actions that are considered prohibited practices, and that includes landlords attempting to do a self-help eviction. So examples of this would be if your landlord's trying to lock you out of your rental home by changing the locks, if they remove your belongings from the rental home, if they're cutting off your utilities, if they're interfering with your access to the home, or if they're preventing you from staying in the home by doing things like removing the doors or the locks or the windows. These actions are known as self-help evictions, and they are illegal and do not follow the proper eviction process. Oh, Charlotte, I think you muted.
It's inevitable that was going to happen eventually. So now that we kind of understand what a self-help eviction is, what is the proper eviction process?
Yeah, it's great that you asked that. So unless you have surrendered or abandoned the property, a landlord has to follow these steps before a tenant can be lawfully evicted. First, they have to give a tenant a written notice of lease termination or a notice to vacate and ask the tenant to leave by a certain date. And the specific type of notice depends on your individual situation. Then they have to file an eviction case in the court if the tenant does not move out by the date on the landlord's notice. Then they have to win an eviction case and get a final judgment order from the judge. And then they have to get a final 24-hour notice, what's called a writ of possession, issued from the court and have it posted on the rental home. And then finally have the sheriff come out to the property and evict the tenant. And then the sheriff will then allow the landlord to change the locks and remove any of the tenant's belongings that are still inside the home.
Okay, so it sounds like there's quite a bit of action that needs to happen throughout the eviction process. So what can someone do if their landlord is trying to evict them illegally?
Right. So first, if your landlord's a reasonable person, you probably should inform them about the law and request that they undo the unlawful action so that you can continue living in the home peacefully unless or until you are lawfully evicted. If you cannot talk with your landlord, or if talking does not work, or if you fear further retaliation, you can do a few things. So one of those is, call the police. They may not be able to resolve the situation completely, but they should be able to tell your landlord to leave the property and stop breaking the law. If your landlord has cut off your utilities, you should call the utility company to request that they turn the utilities back on in your name. And keep in mind, you might also be required to pay a deposit and service charge if the account was previously not in your name. And then additionally, you can actually sue your landlord for breaking the law. Though in general, if you're unsure of your situation, you should either consult with a lawyer or call our organization and apply, and we can discuss your issue. Oh, muted again, Charlotte.
I'm not winning for the mutes today. So you can sue your landlord. How does that work exactly?
Yeah, definitely. So if you can prove your landlord violated the law in an effort to evict you, that is considered irreparable harm. If your landlord has violated the law by locking you out, cutting off your utilities, or doing one of the other illegal things that we've discussed, you may sue your landlord. You may sue for money or for an injunction requiring your landlord to undo their unlawful action. So if you sue your landlord, you should make sure you state in your complaint that you are suing your landlord under section 83.67 of the Florida statutes. And you should also specify whether you are suing for money, an injunction, or both. If you prove your landlord broke the law, you are entitled to an award of your actual damages or 3 months' rent, whichever is greater, as well as your court costs and attorney's fees. Now, actual damages are the amounts of money that you lost or you had to spend as a direct result of the landlord's unlawful action. So, for example, if you had to spend money on a hotel room or if you lost your belongings due to the landlord's unlawful actions, those amounts would be actual damages. If you prove that your landlord broke the law more than once, for example, if your landlord shut off your utilities one day and then locked you out on the next day, you are entitled to a separate award damage of 3 months rent for each violation. So when you file or where you file depends on the total amount of compensation you're seeking. So where you file your complaint, if it's less than $8,000, then it would be filed in small claims court. If it's between $8,000 to $30,000, then it would be county court. And if it's more than $30,000, it would be filed in circuit court. Also keep in mind that when you file, there is a filing fee that you have to pay. In some situations, though, you may be able to request a civil indigency waiver and request the judge to waive your fees if you qualify.
Okay, wow, that's a lot of really great information. So is there any other unlawful actions a tenant should watch out for?
Yeah, definitely. Yes, there's something to watch out for is called retaliatory conduct. Now, this is separate from the prohibited practices, and this is something that's usually going to come up as a defense after an eviction has been filed. But what I really want to highlight is that it's unlawful for a landlord to, either discriminatorily increase a tenant's rent or decrease services to a tenant, or to bring or threaten to bring an action for possession, primarily because the landlord is retaliating against the tenant. And what a landlord or conduct that a landlord cannot retaliate against are basically you exercising your rights. So if you complain to code enforcement or a similar government agency about your situation, if you organized, encouraged, or participated in a tenant organization, if you complain to the landlord about maintaining the property by giving a proper written 7-day notice, if you're a service member who has terminated the rental agreement pursuant to the Florida statutes, or if you exercise your rights under local, state, or federal fair housing laws, that's conduct a landlord can't retaliate against. And any evidence of a retaliatory conduct can be raised as a defense in any action brought against them for possession. So that's whenever a landlord files an eviction against you. Though it is really important to keep in mind that for a tenant to raise the defense of retaliatory conduct, you must have acted in good faith with your conduct. And additionally, the defense may not be applicable if the landlord is evicting you for good cause. So examples of a good cause eviction would be for evictions of non-payment of rent, or if there are any breaches of the lease. But once again, if you're unsure of your situation, you should consult with a lawyer or call our organization and we can discuss your issue.
All right, well, thank you so much, Alex, and thank you for joining us today. And just so everyone knows, this video that we've just done provides legal information and should not be considered legal advice. This video does not create an attorney-client relationship or substitute legal advice you've been given. You may have defenses that we haven't even discussed here, so seeking an attorney or legal help is always advisable. For more information about LSNF and other eviction and housing material, you can go to www.lsnf.org/housing, as you see on the screen, or call us anytime at 850-385-9007. Thank you again for joining us today, and we'll see you again here for our next Justice on the Block.
Bye.